2017 content for final hearing. I have filed an application for expeditious disposal also.
All right. Day after. Huh?
3rd November, my lodge director be listed in court.
Huh?
I have submitted a letter to the registrar.
Why do you want the listing? First tell us.
My lord, this is with regard to the pet shops and the violation of the pet shop rules. We had filed a report with the relevant authorities with the state animal welfare boards.
What PIL?
Yes, my lord.
So why do you want the listing, madam?
So it was your direction for it to be listed on after 4 weeks on 3rd. A record, the report had been taken on record as well by this court. We're just seeking that it is listed as soon as possible as per your direction.
So for final disposal, right? There is no urgency, madam.
No.
We are dealing with 2004 and 5 intra-court appeal. You have done your job by filing PIL. We will take care. No urgency.
It has not.
You have not been able to tell us the urgency.
My lord, the report has.
File an application. No, what is the urgency?
My lord, the report has been pending with the state that has filed with the violations for more than a year. No action has been taken with regard, which is why we were constrained to come before your lordships.
And we'll see next month.
My lord, this is the
Next
matter. My lord, namaste, my lord. This is the matter heard by the previous CJ and reserved for orders when the meanwhile elevated. Then I have mentioned before your lordship. Your lordship directed me to file the application, expedite petition. I
Day
have
after.
filed.
Day after.
My lord.
Day after. For orders on application for early hearing.
Yes, my lord. Already I filed. It is enough.
So day after it.
Yeah.
There is no scope for argument. We are saying day after and your application.
My lord, I might oblige. I'm sorry.
Yes.
Subject to your lordship's kind leave, going to an interim order, this is the writ petition of 2010, your lordship, going to an interim order granted by this honorable court.
Have you filed vacate petition?
Indeed, your lordship. So in fact, your lordship, the thing is the
Do you want orders on vacate petition?
yes, your lordship, the
Friday.
petitioner himself passed away. Your
Friday.
lordship. So therefore, petitioner passed away in the matter. I appeal for the respondents. It will be taken up to that.
Taken up for substitution. What? Ask what she, why she want listing? What purpose, madam, you want listing?
Your lordship,
Either vacate petition or substitution of LRs.
vacate of the interim order, your lordship.
Monday.
Oblige, your lordship.
Sir,
Yes.
WP number 19939 of 2017 matter pertains to the High Court Employees Cooperative Society land. Honorable Supreme Court was remanded on 28 June 2022 to dispose of as expeditiously as possible. Many members are died, many members are retired. Your lordship may kindly have any date, Mila. Entire pleadings were completed, Mila.
21st November.
DPO, DPO.
subject to your lordship's permission, my lord, I have filed a writ challenging the RTI rules of this honorable court. Pursuant to filing of the writ, my lord, this honorable court has brought amendment to the rules. So my main prayer becomes infructuous. My lordship may take it and close the matter.
Day after.
Oblige. Oblige.
Therefore, in the facts and circumstances of the case, as well as for the reasons assigned by us in preceding paragraphs, we do not find any ground to differ with the conclusion arrived at by the learned single judge. Accordingly, writ appeal fails and is hereby dismissed.
Putting today's date.
Yes. Hmm?
Has been deposited, whether the counterclaim which has been allowed in my favor has to be set off or not, with the analogy of Order 21, Rule 18 of CPC.
Yes.
I've deposited entire amount of 100%, my lord, but only, please, your lordship may come to page number, but page number 98, my lord.
What stay you are seeking?
So I have already sought a stay. Initially, 50% stay was granted of article,
What stay in this petition?
not asking intimate, I have deposited entire amount. So lordship may order notice and
All right.
because it should involve
Learned senior counsel for the petitioner submits that in compliance of the order passed by the commercial court, the petitioner has deposited the entire amount. However, it is contended that the question which arises for consideration in this Yes, madam.
In fact, there is a connected matter, my lord, filed along with this writ appeal. Your lordships may kindly be pleased to take it up next week, my lord.
Yes. No, we will list it along with. We are issuing notice, madam.
Yes, yes.
No, not item 3, right? Not 3. What is it? You want it to be listed along with some other connected matter?
Yes, my lord. However,
Which case?
that is yet to be numbered. I filed 2 writ appeals, but this was numbered prior.
Counsel for the appellant prays for adjournment. List. After 1 week or next week?
Next week. Anything.
Huh?
Subject to your lord's convenience, next week or any other week.
Next week.
Yes, appellant.
Issue notice of IA 1 of 23 as well as 2 of 2023 list for analogous hearing along with WA 1035 bar 2023. 6 also same order.
Made, my lord.
Ah,
Against the common order, my lord, 2 writ appeals are filed. One is listed today. The other is also, my lord, the scrutiny is completed to be listed. And
there is a decision of the Supreme Court directly this
yes,
on the point with
Yes.
regard to OTS scheme and issue of mandamus. Have you got it?
that judgment I have filed it in the other writ appeal, my lord.
What is the citation?
That citation is, my lord, 2000. I filed the judgment in the other case also. Citation there. Citation. Yeah, citation, huh? That is, my lord, Bijnur Urban Cooperative Bank Limited.
Citation.
Citation is, my lord, 265 to 73. Civil appeal number 7411 of 2021, my lord. Just it is reported.
You don't subscribe to SSC? Find out, Adam. It's our duty to find out the citation.
I will give it, my lord.
Civil appeal number.
Civil appeal number
He also doesn't have access to SCC. How come, madam? How come you don't have access to SCC here?
ये निकाल दे civil appeal number
Surprising.
7411 of 2020. In fact, I was just
No, it's all reported, mister. It's
Yes,
not
it's
something, I mean, you are citing for the first time. How did I know?
No, it is a fact, my lord. I am
Because I've read it.
I'm
What
sorry.
is
Yeah,
this?
that- yes.
You are a senior, if a junior counsel is appearing, we can understand that he will give, he can download a citation from free website. But what is this? You don't subscribe to SCC?
I subscribe, my lord. It is there, my lord. I have seen it all.
What is this?
Only thing, my lord, that
Civil appeal number, what?
my advocate
It's
has
our
recommended-
duty to find out what is the citation.
Yes. I'm sorry.
So please, everybody watches you. That's our request to you. Please, at least if you want this thing,
I'm
you want to.
not pleased. Yes.
If you want to download it from a free website, you are welcome to do so, but please write by hand on this citation. Find out, madam, what is this law finder
The last para is
submitted by THCM means what advocates of Telangana High Court.
para number.
Citation, Mr. Find out, madam.
Para number 5.
This has to be 2022. So this was 15/12/21. What are you doing, Mr.? Open the file. No, correct. What are you doing? No, not. We are not asking you. In this writ petition, in this intra-court appeal, the appellant has assailed the validity of the order. The not fair to the court, Mr. Issue notice to respondents.
Public.
You got the citation. 2023, volume 2 SCC.
2023, volume 2 SCC
805.
805. Thank you. Yes. Hmm?
I'm sorry, item 7. Your lordships, I'm sorry, I believed it was item 6. I'm representing
She
item
has to call item 6. You have called?
I.
Seven.
I apologize, your lordships. I'm for item 7. I represent item 7, your lordships, if I may. Your lordships,
Have you filed any representation, madam?
Yes, your lordships. I filed representation as well as photographs as well. There have been 2 representations, your lordships, and pursuant to those 2 representations itself, from pages 25 to 39.
Yes, Mr. Pollution Control Board.
Instructions will not in this point.
What instruction?
Skill to closure, issue the closure order, will not with it. Test.
Closure order? No, her grievance, as we understand, is against you. That you are not passing an order against an industry which is causing pollution, not closure order under Industrial Disputes Act.
Closure order, earlier we issued a closure order, not page 77. Yeah, thereafter in the month of June, the revocation order also passed. Now, at latest position, what is the presentation to the file or not?
Latest position?
Your lordships, I filed the representation. Pursuant to that, in December 2022, they came and they did a survey, your lordships. That aspect is there on page 25.
No, so what happened, madam?
After that, no other step has been taken, your lordships.
on page 25 to 31, your lordships would see, especially on page 30, at paragraph
This
9.
is a public interest litigation.
No, your lordships. I am individually affected. My plantation and my fields are exactly adjacent, and my entire mango groves have been destroyed, and my fields also have been.
When have you submitted
Yes, your lordships.
the representation date?
The representation is on page 92 to 95.
Date.
The latest one is in September, your lordships. Prior to that, I've submitted last year also, your lordships. The latest one is on page 92.
The date, madam,
It's,
date. You
it's
can
date-
anybody tell me date?
39/2023. 39/2023.
13 or 30?
13/9/2023, your
And
lordships.
previous one? Previous representation?
Previously, your lordships, I've submitted inspection of your industry. Previously, in April of 2022, your lordships. April of 2022.
April, which date? Yes.
And pursuant to
Learned senior counsel for the petitioner submits that the petitioner is owner of agricultural lands. No, which court has ever done it that without hearing you an order has been passed? If the, there can be two things. If the court is without hearing you is passing an order, that order has to be necessarily in your favor, number one. And secondly, I mean, you should be assured that no adverse order can be passed.
I apologize. No, I can't correct.
He told no that he needs time to seek instructions. For our reference, we are writing facts for our memory. That we can't do. Huh?
I won't come in the.
You should not better, otherwise interference in administration of justice, criminal contempt. Yes. Huh? Case of the petitioner that responds. If you are accepting notice, then we will say so. You are not saying anything.
Fine, my friend, yesterday I have received notice.
Notice on behalf of R8 is accepted by Mr. So and so. You are not accepting, right? Let the notice go. Then why should you stand, mister? If you are not even prepared to accept the notice, why should you appear?
The respondent and appearing, not.
Huh?
The respondent.
Respond number 7.
6, I think.
6.
I have respond number 2.
This all is not this by invitation, mister.
No, just give a note. On 5 and 6.
The advance copy is served to you. Why? So that at least the time in service of notice can be cut short. You just stand up.
Your lordships
Yes.
may give a specific date, your lordships.
What?
Date, your lordships.
April 2022, madam, you have been waiting. Right?
Your
The
Lordship-
moment you come to the High Court, you want the decision today itself with copy delivered to your office in the
Your
evening,
lordships,
right?
after
This is not-
2022, they acted, they came and surveyed, but no action was taken, and then I gave another notice, your
Ah.
lordships. That is this thing.
We have to give them some breathing time,
Yes, Your
right?
Lordships, I'm only,
Merely because you have filed the petition, it can't be allowed to dead cell.
no, Your Lordships, I'm only saying a specific.
We have done right, whatever we could. Yes.
Some time. Yes, Your.
That presentation given by the 2022. Now,
You file whatever a status report, counter, whatever. This is
Yes.
only, all litigation is due to your inaction and you are not adhering to the timelines. That means you have furnished a table.
Yes.
Other council appearing for pollution control board had said that we have prepared a timeline. You are obviously not adhering. Otherwise, 13th September notice, you should have taken action, whatever you should have rejected it, whatever, close the industry, whatever you want to do. This is, Mr. You are a statutory body meant for public and to protect environment, not to this thing harass them by your inaction. Huh?
Oblige, Your.
What I mean, you generate litigation, right? Like this, don't take action. So, someday we will address this issue, Mr. In some petition, you better warn your officers, find out and report to us how many representations are pending. Someday we will, you will not be spared. Someday you better improve your ways of working. Otherwise, we will have to take an action. And you will realize that this court has power to take an action against your chairman and everybody, right? Tell them. It's repeated. I mean, 1 or 2 petitions daily are on your inaction. So you don't decide and then seek time to seek instructions. You are meant for citizens, right? Why his grievance should not be heard? You should have taken a requisite. We don't know. It may be correct, may not be correct. It's a factual thing. Who knows whether he is causing pollution or not? May not be causing. He may be having environmental clearance. Whatever. You have to at least inform.
Oblige, Your Lordships.
I appear this matter.
Yes.
I appear, my lords.
Huh? Yes.
My lords, this is a matter where there is a challenge to the virus of rules 89(1)(b and 89(2)(e) of the CGST rules as being ultra virus, the parent act, as also the SCZ Act and rules. Apart from that, my lords, the challenge is also to the notices which have been issued pursuant to that. Wherein two of my, even though I have challenged the virus of the rules and also replied to the notices, they have not considered this and have issued this show cause notice without any consideration of the grounds that I have put for the other issues. The main challenge, my lords, is to the virus of the rules which require under Rule 89, there's a requirement that those who supply services to the SCZ,
yes,
as distinct from goods, the rules require that the service invoices should be endorsed by the SCZ authority. This is in direct contrast to Rule 30 of the SCZ rules, which itself says that the requirement for endorsement is only for goods and not for services.
All right, we'll issue notice. Yes, learned senior counsel for the petitioner. Heard all the questions. Huh?
My lords.
What?
The present petition, my lord, unilateral appointment of the arbitrator, my lord, made by the second respondent bank. Itself.
Ask him. Will not do it. Whatever. The remedies for 34.
What is the remedy according to you?
My lord,
Section 34 follows section 34.
yes, my lord.
We have not participated here in the proceedings.
In fact, my lord,
Not an ex parte. In fact, notice was issued.
no, my lord, your lordship may kindly see the order, my lord.
No, Mr. The award passed by an arbitrator cannot be challenged in a writ petition. There is a remedy under section 34. You should understand that.
In fact, my lord, the very appointment of the arbitrator itself as illegal, my lord, lordship may, without issuing any notice to my lord to appoint an
He
arbitrator.
challenged the award on that ground. It falls within one of the grounds.
In fact, my lord, the petitioners, my lord, have approached
No,
the
this
civil
thing-
court also, where, my lord, the civil court has found that, my lord, the procedure was not followed by the arbitrator, even, my lord, an interim order was passed, my lord, for deposit of the offer.
The Honorable Supreme Court. And, when civil appeal number 1465 2015.
What?
And the last neighbor. The
What is
remedy, remedy, my lord, in 34, my lord, when
That's what we are telling him. What can be done? We can't prevent him from arguing. He can argue what. The best thing is, Mr. When you are confused, file a writ petition. The court itself. In our times, one of the very senior counsels used to tell. So when we asked him whether a revision would lie or an appeal would lie against an order, he would say, "Why bother me at this stage? You file a writ petition. The court itself will examine and tell you what is the remedy." So he is doing the same thing, filing, and then you can't prevent him. He is not prepared to respond. What can be done? Why earlier I used to get annoyed, but I have decided why to waste energy. Let him exhaust himself. Go ahead, Mister.
In fact,
Argue whatever.
in fact, my lords, under section 34, my lord, the petitioner has also filed, my lord, arbitration OP before the civil court, my lord, challenging,
You have
my
filed a petition under 34.
lords.
Then how can you prosecute two remedies simultaneously if you challenge the award?
In fact, my lord, though the, my lord, the civil court, my lord, has held that, my lord, the procedure was not followed by the arbitrator, my lord, an interim order was also passed by the civil court, my lord. Your lordship may kindly see, my lord, page number 32, my lord. My lord, I will satisfy, my lord, even, my lord, the very appointment of the arbitrator, my lord, is unilateral, my lord, that can be set aside by this honorable court, my lord.
Brother, deal with him before I say anything to you. You deal with him. Yes. What have you challenged in this petition?
My lord, the very appointment of the arbitrator, my lord, unilaterally by the second respondent bank, my lord, is, my lord,
No. I think you are not clear about it. What is the prayer? Read the prayer to know what have you challenged.
My lord, the Kalpat records and to provide the ex parte arbitration award passed by the correspondent arbitrator. That is under challenge, my lord. One of such ground, my lord, since the, my lord, second respondent cannot unilaterally appoint the, my lord, arbitrator without issuing any notice to me, my lord, to nominate him, my lord, I filed the present writ petition. Lordship may kindly, page number 49, my lord, the relevant, I am relying upon a Supreme Court judgment, my lord, which I filed. Page number 49, my lord.
Page
49, my lord. In the case of Dulap Poddar versus Executive Engineer, my lord.
What an award can be challenged in a writ petition, right?
My lord, no, my lord, there, my lord, the arbitrator was unilaterally appointed, my lord. That was, my lord, set aside by the Honorable High Court, my lord, which was confirmed by the Honorable Apex Court, my lord. Even, my lord, the party has approached the civil court. The unilateral appointment was refused by the civil court. The same was confirmed by the
What is the ground?
Lordship may kindly see page number.
Ground is that the award.
My lord,
You deal with him, brother.
the award is, my lord.
To the extent of the trade, you deal with him. I will dictate the order. There's no problem.
My lord,
Deal with him.
What is the prayer you sought in the writ petition?
for quashing the arbitration award.
What basis? On what basis?
My lord, without my,
You only confine your submissions to that.
My lords.
This is a writ petition. You challenge questioning the award, the very orders award, right?
Yes, my lord.
Stating that it's an ex parte award.
Ex parte of,
Though sufficient time was given for you to participate, you did not do it.
in fact,
Please confine on your submissions to that extent.
on 2 counts, my lord, I challenged the order, my lord. One is, my lord, without my consent, my lord, without issuing any notice to me to appoint the third respondent as an arbitrator. The second respondent has unilaterally appointed the arbitrator. This is the one ground.
Was a legal notice issued to you?
No, my lords. That is the, my lord, lordship, I kindly see orders. Page number 16, my lord, for a moment. The very first lines itself, my lord, it clearly shows, my lord.
No, please go to the order.
Yes, my lord. That is, my lord, page number 16, my lord.
Where is the impugned order?
It starts from page number 15, my lord. Page number 16 is the, my lord. May I read, my lord? The claimant, Mrs. HDFC Bank, while their letter dated 19/9/2022, requested me to act as a sole arbitrator to settle the dispute that arose between the claimant and the respondent in respect of the loan agreement bearing number so and so. I have accepted the said reference and agreed to act as an arbitrator in respect of.
Please read para 10. There is a description on the exhibits. A notice was issued, legal notice was issued, exhibit A4, which is returned. You did not respond to the notice. You
No, my
did
lord.
not participate. Where is the question of now you being
No
challenged?
such notice was served upon me, my lord, and the same was also recorded by the arbitrator in the initial lines itself, my lord, page number 16, para 3, my lord, lordship may kindly see. Para 3. I have issued first notice dated 21/9/2022 directing the respondent to appear before me on 7/10/2022. Notice issued to respondent number 1 address returned with postal endorsement as address is left. Notice issued to respondent number 2 address returned with postal endorsement as left. And none appeared on behalf of the respondent. My lord, only the award was served upon me, my lord. No notice was served upon me. Even as per the postal endorsement, my lord, it was as left. No notice was served upon me and no substituted service was also ordered by the arbitrator even before adjudicating the issue, my lords. In spite of the said notices, neither the respondents nor anyone on behalf of the respondents appeared nor filed any objections. The respondent claimant contended that the address for service furnished on the respondent are the last known addresses. However, the respondents are willfully evading the service of notices and hence a service notice sufficient to contemplate under section so and so. The arbitrator, my lord.
We cannot go into this. He has a remedy. Yes, anything else?
My lord, since, my lord, on both counts, my lord, even before appointing the arbitrator or even after appointment of the arbitrator, I was not served with any notices, my lord. Lordship, may kindly, only I will read judgment, my lord, which upon relying upon page number 49, my lord, and I will give it to Lordship. Page number 49, my lord, which is relevant, my lord, in the similar circumstances. May I read, my lord?
Yes.
The appellant, who was the contractor, entered into an agreement with the respondents for carrying on construction of a canal. The agreement provided that in the case of any dispute arising under the contract, matter would be decided by an arbitrator who would be the superintending engineer. Disputes and differences having been arisen between the parties, the arbitration agreement was invoked by the appellant, pursuant whereto the respondent herein appointed the superintending engineer as arbitrator. The said arbitrator passed an interim award. In spite of several requests made by the appellants herein, the arbitrator did not consider his claim and pass a final award. The appellant herein thereafter filed an application under section 8 of the Arbitration Act in so and so in the court of subordinate judge so and so. It appears that the said court, without issuing any notice to the respondents, appointed a retired chief engineer as an arbitrator. When the respondents came to know about the appointment of the said arbitrator, they filed a revision petition before the High Court challenging the appointment of the said arbitrator as illegal. In the revision petition, no order of stay, however, was passed, and as a result of the arbitrator proceeded to make an ex parte award. In the meantime, when the civil writ petition came up for hearing before the Honorable High Court, it with the view that since an award had already been made by the arbitrator, it would be open to the respondents to challenge the appointment of the arbitrator by means of an objection under section 30 of the Act before the civil court. Accordingly, the respondent filed an objection before the civil court. The civil court reflected the said objection. The respondents thereafter preferred an appeal against the said order of civil court before the High Court. The High Court allowed the said appeal and set aside the appointment of the arbitrator
as well as the award given by the arbitrator. It is against the said judgment. The contractor is before us in appeal by means of special petition. We have ordered counsel for the parties, and we are of the view that the view taken by the High Court does not suffer from any legal infirmity. It is not disputed that no notice at all was sent to the respondent before appointing arbitrator. It is also not disputed that the award given by the arbitrator was an ex parte one. Furthermore, such an award which have been made by the arbitrator having been passed without giving an opportunity of hearing to the respondent hearing was illegal and void. We therefore do not find any merit in the appeal, hence it is dismissed. That is the point.
What happened to your 34 application?
My lord, in the 34 application, my lord, an interim order was passed by the court, my lord, on condition of deposit of the stay of the 50%. My lord, though it was held that, my lord, the arbitrator has not followed the procedure. Lordship may kindly see interim order is at page number 31, my lord, it starts from 32 is the, my lord, operative portion of the orders. Last para, my lord, page number 32. Last but one para, my lord, are the land counsel for the petitioner and perused documents. The purview of the petitions and documents prima facie shows that the respondent number 1 is the HDFC Bank filed false statement of loan accounts in respect of disbursement of loan before the second respondent, land arbitrator, and the arbitrator without going into the.
You have already filed a petition under section 34, right?
Yes, ma'am.
And challenging the order in, when did you file that petition?
Let's take the in the month of April, my lord, arbitration section 34 arbitration OP is, my lord, at page number 21, my lord.
This is the order, right? Page
Yes, my lord.
31.
Order is, my lord, passed on 28th April 2023, my lord. 28th April 2023.
And thereafter you have filed this petition also.
Yes.
This petition under section 34 is pending.
Yes, ma'am. My lord, my client instructed me that, my lord, on the next date of hearing, since the, my lord, in the very initiation of the proceedings by the arbitrator as illegal, my lord, and approaching this honorable court, my lord, they will seek necessary steps before the court, my lord.
See, when you are already proceeding there in the section 34,
my lord,
how can you maintain both parallel proceedings? How is it maintainable under 226?
my lord, since
We will, this thing, Mr. This is an abuse of process of law. We will dismiss it by imposing cost of 15,000, 25,000 rupees. Yes, go ahead.
Lordship may kindly see, my lord.
No, you argue whatever, you argue what we are not saying.
My lord,
Yes.
can say one thing, my lord. I also stated in my writ affidavit also, my lord, regarding the, my lord, passing of an interim order by the civil court, and, my lord, despite court has held that, my lord, there is a procedure.
What is the ground you are raising? You are already pursuing the matter. What is the ground you raised in your writ petition? You have to answer that point. Simply filing a writ petition and seeking an order is nothing but abuse of the process of this court.
Multiple forums like
My lord, I
you
will.
should have gone to Supreme Court also by filing SLP.
No, my lord, since the, my lord, in view of the law, my lord, that, my lord, my lord, since arbitrator appointments is as illegal, my lord, I approach this honorable court, my lord. Otherwise, my lord, lordship may decline to pass an order, my lord. I will withdraw the writ.
We will pass an order. Don't worry, you have argued us. You have argued the matter sufficiently. Anything else you want to argue? Anything else? Go ahead.
No, my lord.
That's all. Right. In this petition under Article 220.
May I please, my lords, matter arising under the TSHC Act, lords. What is under challenge is Rule 96, Sub-Rule 10, as ultra-virus, Section 16 of the IGST Act, lords. Section 16 of the IGST Act dealing with zero rate supplies, my lords, imposes no conditions on refunds to be claimed on the zero rate supplies, my lords, while Rule 9610 runs contrary to it. Because identical writ petitions are pending before this.
Oh, yes, that's what we were.
Yes, my lords.
Learned counsel for the petitioner submits that the, no, in this petition. In view of aforesaid submission and with a view to maintain
My lords, I am extremely apologist. I have not filed my application filed before the respondent.
Huh?
I have not, I have filed I have not filed the copy of my application filed before the respondent and the me. Can you give me 2 weeks and let I will file it.
learned counsel for the petitioner prays for adjournment list after 2 weeks.
Please.
He is praying for adjournment. We don't know.
I am appearing for the first response.
Nothing has been done. It's a fresh matter.
Yes.
In the cases where you are required to appear, you don't appear, right? And where the case is being adjourned, you say, I appear.
Sorry. I never.
Nothing has been, he's prayed for adjournment. It's a fresh matter. When it is taken up and order is passed, please argue. We will hear you, not today. What encroachment on government land?
Yes,
So that usual order we will pass yesterday.
Encroachment on irrigation canal.
So
Yesterday's
order. Encroachment, all right, disposed of. So you will have to write something, right? The grievance in this.
of 2020.
Huh?
Bill 18 of 2020. The other day, my lords passed out.
Yes, same. Disposed of. They will take, the survey will be conducted. You will be given notice. 4 to 10 will also be given notice. We will decide and pass an order if it is found that there is an encroachment. An order will be passed. Any person aggrieved by that order can take recourse to the remedy. Police assistance will also be provided.
Yes. Obliged.
Counter has been filed.
In this matter, they're challenging the Rule 9(4) of the Traffic Act. May be necessary for the Union of India also to be made party because they may be the answering respondent. Because it's challenging the ultra vires of that.
Yeah, they said they wanted to take time. I said I'll have no objection because even my colleague is getting married day after tomorrow. So they said they wanted time. I thought I'll leave it to your lordships.
That department of the additional submission is
The choice is there, so what can be done? We'll consider this. You consider impleading Union of India.
We'll do that. I'll file the application.
Petition is admitted for hearing. Learned senior counsel for the petitioner.
I'm sorry, my lord, I think it's an oversight. I'm
Grace
sorry.
warrant is granted. 2 weeks time to enable him to.
I only request the interim order be extended.
Interim order shall continue.
much blessed.
Mr. Rao, what happened? Yes.
My lords, may request, my lords, will file counter, my lord, subject to your lordship. Monday, your lordship may kindly take it up, my lord, will file counter in the meantime.
All right. Yes, let them file counter.
It's a small issue.
You were saying that your grievance has been redressed something. No, not here. Not in this case.
At this thing, my lord, my lord, error has been brought to the notice now to the university and it's now in court. If they realize it's a system error, it's not a human error, it's a system error. There can be correction even now. Instead of inviting the court and to enter into that issue and create a precedent.
Provided, I mean,
Yes.
they are willing to do so. Hey, Mr. One must have the attitude to correct himself.
I feel it's
Then only.
a simple error. I feel it's a simple error. Now it's the court.
It may not be that simple because appearance of Advocate General suggests something else.
Trying to just make it truth, my lord.
Lighter vein, Mr. You should.
Yes.
What is there? Nothing to be so serious. What is he is praying for adjournment? We are granting a short adjournment. What is? There's something you should seriously wrong with a person when he stops enjoying humor. Right? We are only yes. So Monday you will file.
Yes.
Then when do we take it up, Mr. Tennis?
If I'm served, my lord. Beforehand, if I'm served, Monday is okay.
Monday is a holiday, Mr.
Yes, that's
13th.
30.
Closed. Thereafter, any date. 16th.
Yes. Yes.
Learned Advocate General.
But it's going far beyond the admission process. Now it's extended till 15. Now the.
So earliest is then, why don't you, 14th we can take up?
This Friday, if it can.
Friday. Well,
14th.
14th.
Undertakes to file counter on our behalf of response. (14) and 15.
Yes.
Yes.
HIGHCOURT petitioner, my lord. On the orders of this honorable court, notice is served to
Understood.
notice it.
Yes.
Well, this honorable was pleased to direct Lord to furnish the notice issued by medical counseling committee. Lord fixing Lord participation up to only third round. Lord, the case is Lord that the petitioner was not permitted to participate in counseling in the stray vacancy. That is case. I submitted to the lordships Lord that the stray vacancy Lord permission was not given. Lord, Medical Council of India gave a notice permitting the candidates up to third round only.
So she had participated in third round.
Third round already participated.
Stay round not entitled.
Not
she has been allotted a seat.
Seat in Nizamabad, Tirumala Dental College, Nizamabad.
Yes, madam.
Had she been allotted is permitted in the stay vacancy, she would have got seat. That is our contention.
A better seat.
Better.
Senior
Yes.
Counsel M. Surendra will appear in this, my lords. Kindly have it after
After?
2 days.
They are not serious about it. So that's why That's why madam, it's a time bound process, right? Everything you are seeking adjournment by 2 weeks means your senior knows what will happen in this petition.
2 days, my
Ah,
2 days, my
he knows what will happen. The grievance, mark the presence, grievance of the petitioner in this writ petition is
I will give a date. I will give a date.
all right. He will tell the data has already been held on so and so. Learn it at this point. Learn it counsel for the petitioner prays for it. 11/10/2023.
Achara.
Wait, please. Because this is a letter on the basis of which this honorable court took up a suo motu petition with regards to.
They have submitted compliance report. Have you gone through it?
One only part of it has been submitted. The welfare department has, the education department has not. And they themselves say.
I have requested them to furnish the compliance report. Insofar as respondents 2, 3, 4, they have already submitted it.
No.
Kindly grant me 2 weeks time.
So file counter on behalf of?
On behalf of the respondents 1, 5.
So we'll grant them 2 weeks time. Let's see.
Yes.
Learn it counsel for respondents 1, 3, 1.
1,
6. 2, 3, 4. I have filed it.
5 to 8.
On whose behalf you want to file, Mr.
I need to file it on behalf of respondents number 5. 5. She is the secretary.
5.
Yes.
Prays for 2 weeks time to enable him to file counter on behalf of respondent number 2. List after 2 weeks.
Obliged.
Yes, this is to be heard finally. Huh?
AG sir is hearing.
I beg to appear, my lord, in the matter.
Yes.
Lord, it is to be heard finally by your lordship, lord, on a question which your lordship has already, lord, framed.
Let us finish the list thereafter. We will take it up in 5 minutes or so. There are some more motion hearing cases.
Yes.
There are only 2 cases after this bunch. Let us take those 2 cases and then we take.
And there is a batch of writ petitions which have been filed, my lord, also been tagged along with this.
Okay. So all are ready? This side or after next week?
We are respondents in written appeal.
Ah.
We are petitioners in writ petition.
Okay.
So, madam, where to sit, madam, we are restricted.
We perfectly at an ideal place.
We are.
In the midst of the storm.
There are two issues, Millet, now in question.
Yes.
One is, Millet, with regard to the forum, whether, Millet, without a judicial member, a technical member can preside on the proceeding.
Yes.
Second one, Millet, after expiry of 180 days, whether, Millet,
The order continues.
these are the two issues, Millet, like a single judge, in the writ petition, Millet.
No, everybody is ready or we take it up in the next week?
Because, Millet, one aspect, on 22nd November, Millet,
Yeah.
the three-judge bench, Millet, of the apex court,
Huh.
is taking the review of Millet Vijay Madan's statement. Your Lordship, sir, Vijay
Ah,
Madan-
yes, yes.
So, Millet, once, Millet, the review is ordered, Millet, whatever is the result, Millet, will have bearing on this case.
Yes, Mr. ASTI.
Lord, my respectful submission with regard to this is the Lord Vijay Madan Lal did not address on the issues which were Lord, raised in the present batch, and that was not with regard to the quorum. It was on other issues. And so far as the review which is said to be listed before the Honorable Supreme Court, it is only Lord for procedural orders. The review has not yet been entertained, and there is no Lord review hearing on 22nd also. Therefore, it may not wait Lord for the review to be disposed of. If it is to be heard any day next week,
Yeah,
I will
next
even be
Yes, Mr. Which day?
on 14th.
Next
Lord,
week,
may have it
any
on
day.
14th, Lord. Lordship has it on 14th, Lord. I will have the pleasure of appearing Lord in person, Lord.
Arise out of section 5, Millet, where there is an attachment.
Yes, yes.
There, Millet, the section contemplate there should be
No,
reason.
correct, correct. We are at this point of time only asking you a date in the next week.
Yes.
14th,
Any
I have it, Lord. 14th, Lord.
14th November.
14.
Yes,
Suits everyone.
Week of Deepavali, Millet, instead of that, Millet, Monday week, Millet, so that Monday we can list it.
Lord, 14th, I only thought that Lord, Madras High Court is not working. I will have the pleasure of appearing in person there.
So that's a matter. You can be here on 20th also, Mr.
Lord, some
Huh?
other matters are fixed, Lord.
You can a bit like you are an outstation council, so
14.
Then your Lordship may kindly have it, Lord, on 27th, Lord.
27th.
Yes.
Let mark everybody is present. Let the writ petitions, appeals as well as writ petitions be listed for final hearing. On 27th November is holiday.
Holiday. Holiday.
Guru Nanak Jayanti. Oh, you won't have.
Our
Then it can be
show working.
20th.
Lord may have it on 29th, Lord.
29th is green. Green is what? Optional. We are working, right? 29th it can be. 29th November.
Yes, Lord, yes.
29th November 23. Yes.
Lord, Lordship was pleased to grant an interim protection, Lord.
Interim order shall continue
That is
till
all,
next
sir.
date of hearing.
Obliged.
Yes. None for the petitioner. Let IA 2 of 2023 be listed for consideration in the month of January 2024. Third week of January 2024. No. Today the courtroom is empty. What restoration?
Respondent, your Lordship, in this one.
What do you say? Restoration.
Your Lordship, you on that.
For the reasons assigned in the IA number 1 of 23, which is duly supported by an affidavit, order dated 9/10/2023 is hereby recalled in the result WP number so and so 27607 bar 2023 is restored to file. IA is allowed. 1 of 23 is allowed.
Response.
20.
33.
I am for unofficial record.
Yes. What is it?
Last to get instructions, not whether file number My lord, Prabhakar sir requested for pass or my lord. Requested for pass or.
Password. But no adjournment. No adjournment, I said. Hmm.
34 to 41,
Yes.
42.
Yes.
That this player has become infectious.
Oh.
But
Why you did not tell us yesterday? It was listed.
without seeking instruction of the party,
Really, but
since
it has become infectious or not, you know,
we
right?
have the counter, what they stated in the counter, they played the gas
Council for
pipeline.
the 1 minute. Learned count.
But only thing, I request your lordship, liberty may be granted, to avail the alternate remedy with regard to the dispute. There is any dispute with regard to any compensation,
Compensation? What compensation?
the payment of compensation for the purpose of laying the gas pipeline.
Ah.
Even the counter.
Oh, yes, yes.
Even the counter, they admitted that if the petitioner has any grievance, the petitioner can approach the competent authority.
Yes, in this writ petition, comma, the petitioner inter alia seeks a direction to the, no,
Applying for respond number 2 in this matter.
yes, mark his presence for respond number 2. Yes.
Item 43, I'm appealing on the writ petition, my lord. This is directly to be listed with the next matter bill. Right, in view of the counter filed by the government in the writ petition, my lord, I don't want to pursue the matter because they are admitting my title. As far as bill is concerned, my lord, he has to argue, he's for the petitioner. In fact, in 2004 itself, my lord, the honorable division bench then.
Which this writ petition you want to 43?
43, my lord. 43 is filed in 2008. There is an interim order as on
All
date.
right.
No counter is filed till date. But however, they filed a counter in the bill admitting.
All right, so fine. Yes. Mark the presence, learned senior counsel for the petitioner submits that in view of the counter filed by the state government in W.
I confine it only to the fact that the government is not protecting its land. Lord, to substantiate that, my lord, there are 2 orders of the joint collector and 1 order of the chief commissioner land administration, which have formed part of the record, which clearly stated that it is a government land.
So, there are 2 IAs which are filed, IAS 2 of 2019 and IAS 2 of 2021, which are listed in the last day. These are the applications seeking implement. One filed by the petitioner, one filed by one of the respondents to implement the owner of the property, that is the partnership form. The bill, my lord, they made all the partners, some of the partners as parties, but not the owner, the partnership form. So we filed that IAS 2 of 2019, which is there in the today. That is pending. Another case is IAS
of 2021 filed by the Mallet to impeach one public interest petitioner who filed a petition in 2004 and dismissed in 2004. So, well, these two applications are pending.
So have you filed an affidavit, Mr.? There was an order passed on 18/3/2021.
Right.
Asking you to file better affidavit with regard to.
But I'll tell you, Lordships, what happened in this matter is.
No, and what about one thing? What about impediment?
Not impediment, not the rule 16 of the writ rules is much larger than order 1 rule 10.
We should hear, ideally speaking, everyone.
Yes, it's a public interest litigation.
Oh.
I put it like this.
This 2018 matter, much older matters, we will deal with it. We allow the application for impediments and fix a date sometime in January.
Very well.
Right, which IS, Mr.?
Well, here 2019. That is filed by one of the respondents.
Or on IA number so and so and so and so, right? Application for impediment after hearing. Third week of January 20. Next, 2000. Yes, Mr. Oh, yesterday's matter, right? Yesterday's matter. No legal services, not bothered. Must not have come to the court. It's too early. It's too early. Yeah, but they get fees, no? They pay some fees, no? Where is the council, Mr.? Show the names. And the other one, the council for bank will appear. Yeah, you should. It's not. See, I have told them to this thing. Have a note also here so that we can. This is meant for that. So next week onwards, probably. Sheet for making notes. 60 years. Whatever, white paper or a note sheet, whatever. What is it? There is a synopsis here, right? 52A or something. He was telling us. Additional 60 years of the huh? 2009, they told me 60 years. 60? 60. 60. Copy of synopsis. Yes, Mr.
Millet, I'm sorry, Millet, there was some slight glitch. I was preparing the synopsis which my lordship ordered yesterday. Completion by 2:30, I will be before your lordship's court, Millet. 45th item is going. I am for the respondent bank. Almost into time, Millet.
So please argue what is there.
Yeah, certainly, since your lordship directed me to file a small brief synopsis, I'm just completing the synopsis, Millet. I will be rushing to the court by 2:30, Millet. Otherwise, I will argue that because I am for the respondent bank. As your lordship pleases, Millet.
No, nobody is appearing to oppose you. That is the best. This opportunity you must grab it, right?
Then, Millet, there is no.
Nobody is.
I'm grateful, Millet. The petitioner, the petitioner, Millet, who was appointed as a law officer in 1985. The day one onwards, he started behaving a little bit difficultly. Wherever he posted, he never used to work and say, I am the law officer, the chairman should come to me to ask any opinion. And I will not give the opinion unless chairman comes. About 5 to 6 places he was transferred. Especially, Millet, when he was transferred to Bangalore, there was a protest from all the lady staff employees because he was harassing them. Either you transfer him out or otherwise you transfer all the lady officers out of the office. Again, he was transferred to Bhubaneswar. In Bhubaneswar, Millet, the same thing happens. Therefore, Millet, charge memo was given to him. Millet, a charge memo. Normally, I dislike to read it, Millet, but the charge memo itself is so self-explanatory. He wanted everybody to come before him only. The charge memo, your lordship would get it, Millet, at page. Yes, Millet. Charge memo, I take your lordship's Millet. At page 71, Millet. 5 charges were framed. I dislike to read it, Millet, but these 5 charges, Millet, it speaks for itself. If your lordship permits, may I read page 71, Millet? I'm going only by the writ petition and the counter affidavit. After the writ petition and the counter, a number of IAs were filed, number of rejoinders were filed, number of additional appearances were filed. The entire block, Millet, is only by way of additional affidavits, newspaper cuttings, etc., etc. I'll read the charges, Millet.
Which page?
Page 71, Millet. This is dated 26/5/2005, Millet.
26/5.
2005, Millet.
71.
2005, yes, Millet. Page 71. Affidavit, Millet.
Yes.
That on your transfer from zonal office Bangalore, you have reported for duty at zonal office Bhubaneswar on 30/7/2003. On reporting to duty, you are advised to take charge of the legal cell. You are also handed over all the files and appraised of the work of the legal cell. You are provided with a computer. You are advised to get your notes, likes, etc. Then, Millet, para 2. That you are advised to route all the notes and papers through the chief manager, assistant general manager, but you refuse to route the notes, papers through them, stating that they are without any professional qualifications, experience, exposure.
This is not charge sheet, right?
Yes.
Where is the charge sheet?
Charge sheet. About 800 pages, he has filed. So difficult.
Difficult?
800 pages, man.
He may have filed to
I know, 130 minutes.
1600 pages, but the question is the charge sheet.
Page 130 minutes.
See, madam.
130 minutes. Page 130. 130. Dated 15/12/2003.
130.
Yes, Millet.
P33.
15/12/2003.
see, there's something wrong. Like
130 minute, my paper book says it is 130, 130 minute, and the writ affidavit. Dated.
You read.
Whereas it is reported against you that you are guilty of misconduct while working as a law officer at Zonal Office Bhubaneswar. The particulars whereof are given below.
130. After this. No, not coming. Chief, because he's keeping training the patient. No, this. 130, not coming.
15/12/2003.
All right, you read.
Sorry, I'm sorry, my
No, why you should be sorry? 130. Yes.
Yes, whereas it is reported against you that you are guilty of misconduct while working as a law officer at Zonal Office Bhubaneswar. The particulars whereof are given below. This charge sheet is drawn up against you and you are hereby required to submit to the undersigned within 15 days of receipt of this charge sheet a statement in writing setting forth your defense, if any, and showing cause as to why disciplinary action should not be taken against you. According to the Andhra Bank Officers Employees Regulation 81, the charges against you are: on your transfer from Zonal Office Bangalore, you have reported for duty at Zonal Office Bhubaneswar on 30th July 2003. On your reporting at Zonal Office Bhubaneswar, you are advised to take charge of the legal cell Zonal Office Bhubaneswar. You are handed over the papers, files, and also appraised of the works of the legal cell. You are also provided with a computer. You are advised to get your notes, letters typed, taking assistance of the available clerical staff, junior officers. The required law books bought for use in the legal cell at zonal office are also available. Still, you have refused to attend to the work, putting forth the following conditions. You should be provided with infrastructure. You should be given an assistant to take dictations of the notes and correspondence. You being recruited as an in-house solicitor and posted in an advisory capacity. Thus, you have willfully and without any valid reason disobeyed the lawful instructions of your superiors. 2. You are also advised to route all your notes, other papers to chief manager / assistant general manager. However, you refuse to route the papers / notes to the chief manager, assistant general manager, stating that the chief manager and the assistant general manager of the zones are without any professional qualifications, experience, exposure, and expertise in the fields of law. And routing the papers through them is an unproductive and futile exercise, and professional interaction with them is an impossibility, and that there will be of any value addition. Thus, your behavior with your superiors is highly disrespectful and unbecoming of the officer. 3. When you are once again advised to route all the papers, notes to chief manager and assistant general manager, you have resorted to false accusation against Vishnuvardhan Reddy, assistant general manager, that he has openly proclaimed that you should be charge sheeted and that he has also threatened you in the presence of C. V.S. Sharma, deputy general manager, that he will see your end, and if you come out of the office, and that V.S. Sharma, DGM, instead of objecting to the threat of Vishnuvardhan Reddy, assistant manager, has made a further comment in Telugu that Miru Chusukondi. Miru, both of you look after yourself. In Telugu, it means which means that the matter to be sorted out by you both intercede. Thus, you have resorted to making false accusations against your superiors. You are also indulging in correspondence with your superiors using defamatory, impolite, derogatory, insolent, intemperate, and impertinent language. In your letter dated 9/9/2003 addressed to the Deputy General Manager, Zonal Office, Bhubaneswar, you have written that since inception you have been vehemently but most arbitrarily and illegally insisting to route my specialized nature and category of office notes and letters on the specific subjects of law through the chief manager and assistant general manager of the zone without any professional orientation and purpose, since none of you are behaving any professional qualifications.
All right. So what happened? This charge sheet was served. He submitted a reply.
Representation, and then inquiry officer was appointed. Inquiry officer gave his report. The report was given to him for his comments. Comments were received, and then the dismissal order was passed.
So he has been, how many witnesses were examined in the day?
MX 15 witnesses. He wanted from his side. He has asked from the CGM chairman onward should come as a.
No. How many this thing? How many witnesses examined?
From our side, from the bank side. From the bank side, we have exhibited in account about 15 Document
15.
evidence 15, 1-5, my lord.
1-5 witnesses,
Yeah, 1-5 documents, my lord.
not documents, Mr. Witnesses, we are asking.
Witnesses, my lord.
And he was given the opportunity to examine.
Yes, he participated in the inquiry.
Ah,
In the inquiry, he wanted that the DGM general manager should be summoned.
no, what he wanted to become president of India. And then we are asking you about basics, right?
Absolutely correct, man.
So, like 15 documents you filed, how many witnesses were examined?
About 4 witnesses also we have examined, my lord.
And they were given an opportunity to, he was given an opportunity to cross-examine.
Yes, he was.
And he has examined himself.
He has examined himself, he's participated, but then he threatened.
And how many witnesses he produced? No.
No, he did not produce anybody, but he wanted about 7 to 8 persons to be summoned. Those 7 to 8 persons, my lord, when we asked him, when the inquiry officer asked what is his relevance, he said, I will not tell you the relevance, they should come over here. That was rejected. Because there is no relevance at all with reference to the charge sheet. Because mostly it is documentary evidences.
So, this thing, where is the inquiry report?
Minus the inquiry. Yes, ma'am.
Page.
I'll take. I'll 1 second.
18/5/2005.
18/5.
Counter has been filed.
Yep. I'll take your lordship will get the page 136 onward. Page 136 onwards, madam. It runs into about page 136 to 165, madam. Your lordship, which is present P. Satyanarayana charged officer. Different dates, madam. I am not troubling your lordships to entire witness, they are not required. All what your lordship.
Inquiry report page.
136 is a regular hearing proceedings. 136 is a regular hearing proceedings, madam.
No, inquiry report, Mr.
Inquiry report, madam. He has not filed the inquiry report.
He has not, you have also not filed. So what are the grounds of challenge in this writ petition, Mr.? You will have to tell us. These grounds of challenge and how do you meet? Because
the challenge, first challenge he says is the impugned order 1. First of all, he challenged the regulation, madam, stating this regulation is bad in law.
Which regulation?
Regulation 824, madam. He did not. Regulation 24 of the conduct regulations of the Andhra Bank. He has not chosen to file those regulations. In fact, I was preparing the synopsis along with the regulations, my lord, it has reached. That's why I thought I'll come and assist your lordship at 2:30. Doesn't matter, my lord. Because you are.
Doesn't matter. This facility is only created so that you are comfortable.
No, I know.
Video conferencing.
Yesterday evening, yesterday I was grateful, my lord. The whole night I prepared it. I was about to get it, come back to the court and then request your lordship to give it. But unfortunately, it reached very fast. My unfortunately.
No, unfortunately, fortunately, it should reach. We want every day to be so fast. What is unfortunate about if cases are being heard? All cases are being heard, it is unfortunate.
No. My fault is.
Strange, Mr. Please go ahead. This is all irrelevant. Go ahead.
Then, my lord, your lordship would see, my lord,
If you can tell the grounds, otherwise we will look into the petition. What are the grounds?
The grounds, my lord, I will not trouble you. There are about 52 grounds, 72 grounds if he wish. His main ground was the regulation is bad. Then, my lord,
What regulation you must tell us? What does it provide for? How it is bad?
Conduct regulations 24, my lord. It's not for your lordship. The conduct regulation 4. Acts of misconduct. I read it, my lord. Conduct regulations, acts of misconduct. It has defined acts of misconduct. It read like this.
It defines misconduct.
No, it only says what are the acts of misconducts.
So that defines misconduct, correct?
Yes, madam. Yes, madam. A breach of any provision of this regulation shall be deemed to constitute a misconduct punishable under.
Where is the regulation?
The regulations, my lord, I was.
Are with you.
No, my lord. Regulations. In fact, I gave the entire book set earlier also before the 2-3 learned single judges. I don't know whether it is available in the file or not. In fact, 2-3 photostat copies and gave it. But my lord, it's got checkered history, my lord. It went from one judge to
There
another.
is nothing, no checkered history, mister. It's a simple case. As being the misconduct inquiry being held and order of punishment being passed, upheld by the revision, appellate authority and reviewing authority. Nothing, no checkered history.
Regulations are
Still, stop making an attempt of seeking an adjournment, at least for now. Please go ahead.
the regulations, my lord, I have filed in a booklet form to the honorable court, my lord, and I do not know whether it is there or not, but I'll read it out, these regulations. This is what it says. A breach of
Highlight with, you give the regulation. Come, 230 we will take up. 230 we will take up. There is, it's not on record.
I'll be at your lordship Thursday at 2:30, my lord. I'm
230.
yes, along with my this.
230.
Yes, I'm grateful to your lordship.
230.
Yes, I'm grateful to your lordship.
One more judgment must be there. No scope of departmental inquiry. Scope of judicial review in a departmental inquiry.
Department, yes, my lord.
It's not the judgment.
Yes.
Yes.
2:30 I'll be there.
At 230 we will take up your case.
I'm very grateful.
Come at 230.
I'm grateful to your lordship.
No, we only want a copy of regulation. Otherwise, see, we don't have assistance from the petitioner, so therefore we are banking upon you. We will have to deal with the challenge. Yes.
I will be before your lordship.
You have the copy of regulation.
Yes, my lord.
This is the regulation for.
You have the copy of the regulation. No.
I'll give the details, Lordship, at 2:30. I'll check out with the petitioner in the form only, and this 50.
No. You have the copy of regulation.
Right, sir.
24. You don't have. Come at 2:30. Yes.
My lord, the cause in the writ petition doesn't survive, my lord. The HRA has been revised by the respondents itself.
46. Learned counsel for the petitioner submits that the cause in the writ petition does not survive for consideration. In view of opposite submission, the writ petition is dismissed as infructuous.
Obliged.
My lords, in this matter, my lords, I am permitted to withdraw the writ petition, my lords.
Oh, learned counsel for the petitioner seeks leave of this court 47. To withdraw the writ petition, the same is therefore dismissed as withdrawn.
Obliged.
With your lordships, kindly, I apologize. The item was showing as 48. Your lordship, there's been a GO which was issued in the year 2020, where the outdoor advertising agencies, their businesses were stopped for the last 3 years. Writ appeals filed against those, the GO were dismissed, and an appeal has to be filed by the clients. They're going through a little bit of discomfort, your lordship, because they've not had business for the last 3 years, and there is conflicting advice instruction.
No, madam, they are going through uncomfort, whatever they are uncomfortable, that doesn't prevent you from arguing this case.
No, my request to your lordship is to post it after 2 weeks, because I'm
No.
getting conflicting instructions from the
No,
clients.
no.
There are 9 writ petitions.
No, sorry, madam. After 13 years, we will not adjourn it. Sorry. We will record that you are seeking time and we are rejecting it. If you have to argue otherwise, we will not. This 13 years old matter, we will not adjourn. Sorry.
May I request your lordship to take it up after lunch so that I can speak
No,
to them
no.
and report no instructions, your lordship, because a few clients have asked me not to argue specifically in writing.
Also, you say that no instructions, we will record. Learned counsel for the petitioner submits that marker possess appeal.
Fifty,
59 also, madam?
uh, Your Lordship, there are 9 items. I have,
Up to 55.
yes, Your Lordship.
All right. That's what we are asking you. You at least you can tell. That means you have not even seen the call list also, right?
I'm so, no, Your Lordship, I'm sorry, I'm suffering,
Then,
there's some personal inconvenience with the Wi-Fi being down for the last
all
24
right.
hours.
57 also.
Yes, Your Lordship, there are 9 items. Yesterday's list, it was different
1, 2,
numbers.
3,
Right now,
4,
the
5,
Wi-Fi is
6.
down. I apologize.
All right. Yes. Thank you. Yes.
I remain obliged to Your Lordships.
56. Yes, madam.
I'm representing for the petitioner, my lords.
Ah.
My lords, the petition is a paper mill. This is a writ petition. The respondents. This is writ petition is filed against a property tax demand by the respondents, my lord. This is the writ petition is filed against the property tax demanded by the respondents, my lord. In fact, my lord, the petitioner had become a sick company and it was referred to the NCLT, my lord, and the committee of creditors have approved the resolution plan also. Thereafter, my lord, in the resolution plan, they specifically observed that all claims against the petitioner paper mill cease to extinguish. All previous and any future claims also cease to extinguish. If I may just pass on a copy. I mean, this was also observed in a similar case by this honorable court. If I may pass on a copy for my lords.
A good idea, no? Borrow money from everybody, go seek and nobody can recover. What a brilliant idea. No?
15, it was referred to the
Lighter vein, madam, you can smile, right? There's nothing. So, what a brilliant idea. Borrow money from everybody, go bankrupt, go to NCLT, seek an order. Nothing can be recovered from you. Be happy, right?
taken over by JK Paper, my lord.
Whatever.
And this matter pertains to electricity demands. Para 7, my lords may see.
No, this thing, this covered, right? By this.
Yes.
Learn it.
No, para 7 is the relevant para. Para 63 has been extracted. That is the relevant para from the NCLT resolution plan.
Learned counsel for the petitioner submits that the control.
Yesterday's matter, my lord. Yesterday's batch, your lordship thought.
Yesterday, the my lords disposed of Bill 18 of encroachment matters.
Yesterday, your lordships directed Abadi lands.
Abadi land?
Yes, yesterday, your lordship passed an order to directing the collector to
The order has to be passed on
government land. Encroachments on the government land. Bill
the
18.
usual order.
Yes, bro. 58 to 61. 58 to 61.
That order which was passed in PIL has to be passed.
Yes, bro.
All, this thing. Sarita, madam. 58 to 61.
Yes.
Same, my lord, 58 to 60, 61 both, all.
Ah,
Same order may be passed, my lord.
all right. This encroachment removal order 58 to 61.
Your lordship directed to collector to conduct
Ah,
inquiry.
yes, collector will carry out survey. He will give notice to everyone. You can file documents in support of your claim. Then he will take an action. If if it is found to be a public land, action shall be taken for removal of encroachment in accordance with law. This is the order. You know, yesterday we have passed removal.
Protect the right of the parties also.
The parties have been given the liberty also to challenge the order.
Very well.
Yes.
Other parts under the
Huh?
Provident Fund Act proceed under challenge.
Huh?
Other parts not under the Employees Provident Fund Act is under challenge.
Employees Provident Fund?
Because the petitioner is a society registered under the Societies Registration Act. And the city is imparting menors various services, voluntary services menors without taking any charges from people. Menors, the memorandum of association, memorandum menors of the petitioner is filed menors, which is on record. Kindly see menors the aims and objectives of the petitioner at page 73. But the impugned order says, my lord, the petitioner is an educational institution, therefore covered under the Act, and does not enjoy any exemption under Section 16.
Ex parte order means, did you file an appeal against this order under 7I?
Order dated 29/7.
So against this order, an appeal lies under the Act.
So appeal has been filed. Appellate order is also under challenge. That is at page 27.
So what grounds?
So may respect.
So where is the order passed by the this thing authority at the first instance, second respondent?
First instance, my lords, at page 34.
34.
On 3 counts, my lords, the findings have been recorded. Kindly see, my lords.
1 minute. So it was a sort of a notice you were asked to appear on 29/7/2004.
Yes.
What happened?
Thereafter, an order is passed on 29/7/2004. Page 29.
Page 29.
Yes. Nonetheless, my lords, in the proceedings dated 27/7/2004 itself, that the issue has been decided that the act is applicable to us. In spite of that, my lords, again a proceeding has been conducted. Page 29.
After hearing you, the order has been passed.
Page 29, the order begins, my lords. The operative portion, your lords may kindly see notes at page 31. But this is purported to be an order passed conducting inquiry under 7A. Ultimately, what is stated, last penultimate paragraph, last but one paragraph at page 31. And this solely takes the basis of the earlier order passed on 27/7/2004. While the authority was required to look into minutes and decide the matter as to whether the act is applicable or not, places minutes the basis of the order dated 27.
Permit us to will. Where is the order passed by the appellate authority?
Appellate authority order is at page 27. It's the order dated 29/7/2004, which is questioned in the appeal. Lordship may kindly see minutes at page 31. Though my lords, the authority was required to consider the applicability of the act to the petitioner, it places reliance on its earlier proceedings dated 27/7/2004 to render a finding. However, since the applicability dispute was decided and conveyed properly to the employer by letter dated so and so, it is the time to assess the dues. It was also made clear that PF authority would be forced to assume some expenditure as salary for the assessment of PF in case of its non-cooperation. What was decided on 27/7/2004 is decided by notes in 29/9/2004 order minutes without appreciating the facts minutes and the contention stated by the parties. Thereafter, minutes the appellate authority has not put into minutes the issue as to whether the authority minutes which has inquired into the matter has considered minutes the contentions put forth by the petitioner. Kindly see minutes the order at page 27. Grounds minutes are at page.
So why do you say the act does not apply to you? Because you are exempted.
Petitioner is a society. It is engaged in some voluntary activity minutes. It does not take any profit except for accepting some funds.
Foreign funds.
And then minutes.
Foreign funds.
Foreign funds, apart from foreign funds, the central government.
So petitioner is a society engaged and so therefore not an establishment.
It is not an establishment.
And if it is an establishment, then exempted under section 16, right?
16.
How, under which this thing? Employees Provident Fund Act?
Section 16.
Ah,
The act not to apply.
1 minute, one. How does it, the act defines, there is no definition of establishment, right?
Establishment is not defined.
Not defined. Section 16,
Section 16.
let's see. Not to apply, yes.
The act shall not apply to any establishment registered under the Cooperative Societies Act or under any other law for the time being in force in any state relating to cooperative societies, employing less than 50 persons and working without aid of power. B. To any other establishment belonging to or under the control of the central government or a state government, and whose employees are entitled to the benefit of contributory.
No, so you are a cooperative society?
Yes.
Huh?
Yes.
You are registered under which provision?
It's under the Societies Registration Act, Delhi.
Huh?
Delhi Societies Registration. That's a filed a copy. 38 page.
You are in Hyderabad, right?
Minutes, this institution has minutes the services being rendered all over India. Hyderabad is one of the offices. That's my
You are registered under what, Delhi Cooperative Society then?
minutes. Page 72.
Under Delhi Cooperative Society Act,
The Societies Registration Act 1860.
Central Act.
Central. But it was registered in Delhi.
No, wherever it is.
Yes.
No, but society is different from a cooperative society, right?
It is different.
Huh?
Society is different from cooperative.
Cooperative. So you don't fall in clause. No. So therefore you don't fall under clause A. Correct?
The A says 16A. To any establishment registered under the Cooperative Societies Act or under any other law for the time being in force in any state relating to cooperative societies. Employing
Societies Registration Act. So this is not a law relating to
cooperative societies.
clause A does not apply. Then
Insofar as the establishment is concerned, it is
old age pension and this you fall under B. No.
under 16 minutes.
(16)(2) notification has been issued.
To the extent of this particular institution minutes, no, though there was a request made, such a exemption was not given.
What your submission is that you are a society and therefore exempted under section 16.
Yes.
What else?
Minutes on the order that is passed, minutes.
On Telangana Societies Registration Act 1860, madam. Put a flag and give it, not the book like this. So what is you are a cooperative, so you are a society, therefore act does not apply.
It is not any profit making institution, it is only rendering voluntary services.
So you are relying on section 16, right?
Yes.
Anything else?
That's all.
Okay, thank you. Right. Yes, madam.
This is not petitioner establishment is not if it is not under Cooperative Societies Act. If the petitioner wants to exempt
When I was practicing as a lawyer and the court is proceeding to pass an order without hearing me, I used to feel happy and used to immediately sit down. Today we have to repeat it twice that as if the court is not hearing you, the two presumptions, right? That the order is going to be passed in your favor. In any case, that order can't be against you. Correct? Huh? Yes. His only case is 16. In this writ petition, comma, the petitioner inter alia
To represent Sri Madan Mohan.
Hmm.
The present writ appeal is filed without questioning the order of the land single judge dismissing the writ petition.
Hmm.
Though admitting that the petitioner is in possession and the position was protected by the Honorable Court in by way of interim order in another writ petition. In fact, the present writ petition is filed by the petitioner. The interference of the first and second respondent at the instance of third and fourth respondent. Though the third and fourth respondent, when interfering with the position of the petitioner.
So what happened? There was a transformer has been erected.
Yes, erected, and the contention of the now the implicated party. He stated that the transformer was erected and the.
What can be done? That was an order of restraint you were seeking. It has been installed. Now your remedy lies in seeking damages or whatever.
The land single judge stated that he can claim the compensation in the event of the government is consider his application for regularization. If the application is coming in my way, that they cannot consider now, but they state that now the position was handed over to the Transco, your claim will not be considered. But he purchased the property in the year 1997 by way of registered sale deed.
So what has happened? Your sale transaction has been regularized.
But still it is pending with the government. In fact, the revenue authorities has not filed any counter in the petition.
They need not file.
It is at the
How are it? Correctly so. How are you the owner of the land?
But by way of registered sale deed, in the year 1997, page 18 is the registered sale deed.
No, that an order of regularization has been passed.
Till date, it is pending.
That's what it says, that till you become the owner, how can you this thing, and this has been done. The issue has been rendered academic now. Yes. Correct. This mark the presence. In this intra-court appeal, the petitioner has assailed the validity of the order dated 6th of July 2012, passed by learned single judge, by which writ petition preferred by the appellant has been dismissed. Paragraph facts giving rise to filing There is nothing. You decide, you have filed the rate appeal, that's why they are not deciding.
They may say that the writ petition is dismissed. For that reason, we were.
How can, and this, Mr. This transformer has already been erected. What can be done? You should say that it has become infructuous.
My claim is 986 square yards. Now they are saying that it is 867 square yards only handed over to the Transco.
But you are not the owner, right?
In fact, I purchased the property from the original owners in the year 97 itself. Since now, after that, the government is claiming that land belongs to the government.
When you file a suit against government seeking declaration of title, that we can't do in a writ petition. And Mr. Additional Advocate General will not contest that suit, right? He is filing, so he is telling us that in case such a suit is filed, the government will not contest. What can be done? Yes, okay.
Only seeking with that application may be considered independent.
But this is not the scope of the petition, Mr.
Declaration application is pending with the government till date.
So you should have filed another petition seeking if they are not deciding. This is not the scope of the petition. Yes.
Like
64 and 65, my lord, I am appearing for the appellants. But I need to take steps, my lord. One is that I have to implead the state of Telangana because this writ appeal was filed when the state was composite. And secondly, my lord, the appellant name is also changed after the bifurcation. Earlier it was, so my lord, on 3 grounds, I need at least 3 weeks time, my lord. Now the present one more application is filed.
Learned counsel for the petitioner appellant. Praise fund is granted 3 weeks time to enable him to make application seeking impleadment as well as correction of the cost.
As I understand, my lord, the original allotment made in favor of the present appellant was cancelled by the Telangana state government after its formation.
After resumption, my lord, there is a writ petition status quo is pending.
Yeah, so those resumptions also would be relevant for.
Yes, that's what I want to bring all that. Status quo is there in that writ petition filed against.
Yes, after 3 weeks.
Yes.
But those writ petitions also make, 3 weeks is fine, my lord, but those writ petitions may also be.
Please move an application.
Very
Please.
well, we'll
We'll link it. Yes.
This petition is filed.
29 December, whenever we see you, we remember, right? Huh? You have, huh?
That is a fact,
No, you have. No. We are not concerned with the government. 29 December, you said that I will report compliance.
Yes, now article reported, your lordship, in the strict letter and spirit of the lordship order, we have filed an affidavit whereby we have taken undertaking that is on record now. It is brought up.
It should happen, right? Election should happen. Right. Yes.
This case, instant case, I am taking a venture to argue against the division bench judgment of this honorable court, where under challenge before this honorable court, dated 22/7/2030, wherein learned single judge has followed the simple judgment of the division bench of this honorable court, but facts are like this, my lord. By repealing the Principal Act of Urban Land Sealing Act of 1976, my lord, repealing act.
Ready? Yes, but are you seeking a reference to this thing?
My lord,
No, we want to know from like what.
My lord, that judgment is against us, my lord, that is I am taking.
So then?
That judgment, because still, that factually, I am trying to make a distinction between the case which were decided.
So you can say that your endeavor is to show that the division bench judgment does not apply.
My lord, while repealing the Principal Act, my lord, while repealing the Principal Act, my lord, Principal Act of Urban Land Sealing Act, by repealing Act, the two categories of the lands are saved. One is where government has taken over the possession under Section 10(3), those lands are saved. Second category of the lands which are under Principal Act are exempted. This matter comes under the exemption clause under Section 20 of the Principal Act. But the fact remains is that in this matter, these are the, by exempting the lands, certain conditions were imposed. Well, you will also will find it page number 46A of the middle paper. These are the conditions which were imposed for exempting the lands.
46A.
46A, my lord. This order pursuant to the repealing act, this order memo issued by the state government saying, your lordship will find it by adapting, you'll have to get it, man. By adopting the repeal act, the state of Andhra Pradesh, the following circular instructions are issued. Only cases in which possession of surplus land taken by the government under section 10(6) will be saved.
Where it begins like you are reading from somewhere in between after subject jumping.
Read the subject, my lord,
urban land.
4, my lord, but the unnumbered paragraphs, my lord, 4. While adapting the repeal act that was passed by the central government, while adapting that act of say this repeal act, these are the conditions which were nothing but reiterating the saving repealing act. A is that category of lands under section 10(3) and 10(6) only cases in which possession of surplus land taken by the government under section 10(3) will be saved. Second is all cases in which after passed under section 20 subsection 1 shall be saved. And further, action should be continued in future in those cases only as the principal act had not been repeated. My lord, these lands which were exempted is a fact. My lord, these lands are saved. My lord, the learned single judge has taken a view at page number, my lord, 13, my lord, your lordship may kindly see. The question 13, my lord, this is the judgment of the learned single judge, my lord, relevant to page number 13, my lord.
So what it is not exempted?
The exempted, but that should have been withdrawn. Exemption is there, continuing as on the date of repealing act, that is 27/3/2008. The exemptions which were granted have not been withdrawn. These proceedings would get lapsed. Ultimate effect of the judgment of the learned single judge is the proceedings would get lapsed because exemption had not been withdrawn by the state government.
Correct.
Is what
that is the effect of section 4 of repeal act, right?
Yes.
Proceeding would abate.
Is what the division bench of this honorable court has also taken view that with the great respect that the view taken by the learned single judge, the division bench is wrong.
It's correct.
I submit well. It is. I'm perfect to only submission. How that?
No, we will not record your submission that you are saying it's correct.
The question, Millet, that's nutshell. That is a point, Millet. Division bench, if your lordship so looks into the division bench judgment, Millet, that is nothing but repeating 65. Your lordship may kindly see the learned single judge has followed the division bench judgment of this honorable court. That is at page number.
What is the finding?
Findings given by once it is not exempted. Exemption has not been withdrawn. The proceedings initiated under the old act, principal act, are get lapsed. Therefore, my lord, that was the view taken by the division bench of this honorable court while upholding the judgment of the learned single judge at page number 66. Your lordship may kindly see 66. When the principal act itself is, this is the extracted portion of the learned single judge order there on that, my lord. Your lordship got it, my lord. When the
1 minute.
page number 66, division bench order of the this honorable court, my lord.
What is the proceeding dated 24/6/2011, 3/2011 which have been quashed? Set aside.
That It's a memo issued by the state government, my lord, at page number 42, my lord.
Yeah, what is it? You have not told us the facts, right?
Proceedings were issued by the state government saying that since the exemption land that had been exempted will not get lapsed. So the lands, one is the possession taken over by the government will not be lapsed. And once lands are exempted, that page number will not be lapsed. Therefore, my lord, the lands which are exempted deemed to have taken over the possession by the state government. That is the stand taken by the respondents in the memo. Well, the fact remains, the reason which said, once you have not withdrawn,
correct.
Once you have not withdrawn the exemption, these proceedings will, under the old act would get elapsed. That is the view taken by.
Correct.
Well, the rights which were not approved by the Principal Act cannot be. The Saving Class Act, the Central Saving Class Act, the 1955 judgment, Morsing judgment, where the rights which are not accrued are privileges conferred. When this class, Principal Act applies, no rights accrue to them, to the respondents. No rights accrue to them because that was an exemption order. Maybe it's a fact that that has not been withdrawn. However, rights are not accrued to them because lands have been exempted for the purpose for which that exemption was granted. Here, the exemption was granted for the purpose of manufacturing defense pieces and defense computer pieces for rotors. The conditions have been defeated by the respondent. They have not carried out the business for which exemption was granted. Unfortunately, this point also may come out by the division by saying that since it was not withdrawn, that's when I'm not seriously harping on that point. Let's see.
You should not seriously argue anything. Seriously means you should seriously argue, but you should smile also.
That's why it is said, well, division bench.
Yes,
and,
correct.
To my discount teacher and Sharkin and embarrassment. This division bench judgment has covered this point, my lord. These are my list of dates, my lord, if I am permitted to circulate. Brief note. Page number 66, division bench.
And as the single judge followed the judgment in the division bench, solvable form. In addition to that, otherwise also after the repealing act, but saving of exemptions granted under 21 is for the purpose of any amount is collected. But that should not be asked to be returned. That is the purpose for which it has been done is what the single judge said. in the earlier matter, and which has been confirmed by the division bench. That has been followed here. In this case, my lord, a particular company has been granted exemption. There was a notice to them saying that you have not complied with the conditions of the exemption. Reply has been granted, my lord, seeking extension. It was pending consideration. Never there is an order passed, my lord, cancelling the exemption orders and applying the provisions of the Urban Sealing Act. So that's how, my lord, the application which we filed, which has been rejected, my lord, as your lordship have asked, my lord, what are the proceedings, my lord, of 4th March 2013 and, my lord, 24th June 2011.
4th March.
4th March is at page 39, my lord, and 24th June is, my lord, 2011 is at page 42. But these are the proceedings.
4th March 2013.
Yes, 2013. At page 39, my lord, of the papers. And, my lord, 24th June 2011 is at page 42 and 43, my lord. But these are the proceedings, my lord. What has happened, my lord, the present respondent. But because of the amalgamation of the company, my lord, present respondent has become the owner of this property, and this property has been allotted in the company law, my lord, High Court orders of Bombay and Karnataka. So after it become owner, my lord, now after the urban sealing, my lord, has been repealed in 2008 because 99 is a repealing act, but AP, my lord, legislature adopted it on 27th March 2008. So that is the date on which, my lord, repealing act has come into force in so far as state of Andhra Pradesh is concerned, 27th March 2008. That was the date on which the, my lord, resolution has been passed by the assembly adopting the repeal act. My lord, the present respondent, my lord, whom I am representing, my lord, filed an application seeking the change of land use. That has been rejected, saying exemption has been granted to the earlier company and they have not complied with the conditions. And in the meanwhile, you have acquired the property, you should have declared under section 15 after the Urban Sealing Act has come into force. You have declared, you ought to have declared. So that is the reason, my lord, they say that exemption which has been granted to the original company will revive, and you will not be entitled to seek for the, my lord, change of land use is the reason on which it has been struck down. But it has been dismissed, my application has been dismissed. That is what was under challenge, my lord, before the learned single judge. And learned single judge was pleased to hold, my lord, as long as the exemption has not been withdrawn, my lord, by passing an order, urban sealing provisions will not apply. Because what was exempted at 20 when exemption has been granted is section 4 to 19, which includes in 15. So if you cancel the exemption, then all that would have come, but then now nothing can be done. Even if exemption would not have been granted in these facts of the case, and we have done nothing, and no proceedings have been continued, but adjudicating the excess vacant land. So that's how the act itself cannot be now applied. And saving clause also will not come in, but that is the reason why the repetition has been allowed, but according to me, rightly it has been allowed and it appeal deserves to be dismissed is my submission. It's one aspect. And my friend said, division bench requires to be reconsidered, but without saying.
I did say that, but if possible, I may distinguish.
No, but that's what.
Well, at that division bench order, well, at time being, Supreme Court has granted status quo. Well, that is also discussed by the Leonard Singer judge, saying that that status quo will not operate against third parties and it will not bind. That is what the Leonard Singer judge. We have brought to the notice of the Leonard Singer judge the factor that status quo granted by Supreme Court. That these are that argument also negated by the Leonard Singer judge unless the judgment reversed.
As your lordship know, there is no suspension. Status quo would be with reference to that particular facts of the case.
That is what
Principle which has been decided by the division bench of this honorable court confirming the earlier single judge judgment will operate. That is what the learned single judge just said.
It's considered, and these facts are given, right? Yes, this intra-court appeal has been filed against order. Let's see. This you can also do this.
This intra-court appeal is filed against the judgment dated 22/7/2013 and WP number 1192/2013.
Yes, my lord, that is it. Page number,
No, you have stated in your brief note, para 5,
special officer, my lord.
special officer. Are you special officer from the LC?
That's a pick up. All right. Obliged.
May I make a submission? May I make a submission, my lord?
I will dictate in that 230 matter, so I conserve my energy. Yes.
May I make a submission, my lord? Well, in this, along with the bill, there are 4 connected writ petitions that have been filed that are connected with. But I have bundle of only 1 writ petition and other 2 writ petitions. It appears the advocate who filed those writ petitions is in Amravati. So I'll have to take instructions with regard to those 2 writ petitions also. May I request you last to take up next week, my lord?
What is this petition?
My lord, this writ petition in short, my lord, to protect the government land, my lord. It's the nature of a hillock, which is popularly known as the Chodappa Gupta. So, to protect this hillock, my lord, this present writ petition is filed.
You have filed.
Yes, my lord.
It's
So
a
the
government land.
my lord, the
So who has encroached on the government land according to you? Respondent.
respondent number 9, the respondent number 9 encroached into the.
And who are you?
My lord, I'm a social worker. I'm a social worker, my lord, where to protect the water ponds and.
Trade union leader.
Yes, ma'am.
Trade union leader.
As well the trade union leader. My lord, this is a very prominent hillock where, my lord, the common people nearby these who graze the grass and which is also not cultivable land. And my lord, when there was a certain sale deeds were executed by making a layout by the respondent number 9, then the respondent number 3, the joint collector has inspected and conducted an inquiry and found that, my lord, this is a government land. And thereafter, a writ petition was filed before your lordships in WP number 2129 of 2015. My lord, that is also tagged with this. In that, my lord, a counter has been filed. That counter can be treated as a part of all the writ petitions, which was the earlier order. May your lordships may kindly see.
No, that's correct, but he is seeking adjournment.
Yes,
Why?
yes.
Next week.
Why you are seeking adjournment?
There are 3 other writ petitions that have been tagged on, my lord.
Which other petitions?
Yeah.
Number
15, 18 and 16.
So those bundles, my lord, I don't have those bundles. The advocate who filed those writ petitions.
Next week.
Yeah, very well.
You are appearing for?
I am for respondent number 9, my lord.
Learned counsel for respondent number 9 prays for adjournment to enable him to prepare the case. No, what 69 and this thing? Achha, up to 70 it said there. Okay. 70. Who is there?
Respondent number 19. Chief. Member Secretary, Legal Services.
32. These both 76 and 77 because they so these are all connected matters.
Yes, Your Lord.
May I make one submission and fellowship permits? At 76, 77 and 80 wanted one particular lake, my lord. 2 writ appeals and 1 bill. But all these are different lakes people have filed, they have been clubbed together.
No, last date the learned counsel who's standing, you made a prayer for clubbing, right?
Yes, ma'am.
Prayer for clubbing. Last occasion, member secretary report was filed and your lordship granted time.
That was some other case.
That will be coming up tomorrow. That is,
Other case.
that will be coming up tomorrow, your lordship. This is totally
So,
something.
Mr. There is some difficulty. In some of the matters, his lordship has appeared.
Yes, sir. 76, 77.
Ah,
His lordship's
so,
appeared.
so that's why it has to go before a bench.
Then, my lord, let it be 80 also be assigned.
Some other case.
Huh?
That will be coming up tomorrow. That is,
That case.
that will be coming up tomorrow, your lordship. This is totally
No, Mr. There is
My lord.
difficulty.
Yes, ma'am. 76, 77 and 80, my lord.
His lordship has appeared.
Ah,
76,
so what is this echo going on? Tell me.
So that's why it has to go before a bunch.
No. What I said is also can be heard.
My lord. Oh.
What's the
Yes,
problem?
lord. Your lordship's indicated that 76,
So-
77 may go before another bench.
So it has to go before another bench, right?
Yes, along with 80, my lord.
Petition be listed before these petitions be listed before a bench in which one of us write his lordship's name. He is not a member.
Including item 83, my lord, because
Huh?
it is connected to item 80, including item 83.
My lord, am I audible, my lord?
What's it?
Yes, lord. Your lordship's indicated that 76,
This
77.
is item, madam, 71 to 84.
It has to go before another bench, right?
84.
Petition be listed before these petitions be listed before a bench.
What is this happening? So we have that service matter, right? Madam, at 2:30, that service matter. Hmm. '71 to '84.
What is this?
That was the bench in which one.
71 is different. My lord, 71 is
We have
different.
that service matter, right? Madam, at 2:30, that service matter.
My lord,
Your voice is.
my lord.
Yes. Please unmute yourself, madam. Unmute yourself. We are unable to hear you.
At 2:30, that service
My
matter.
lord, 71, 75 are different, my lord.
Yes.
Those matter belongs to Malcolm Chiru, my lord.
Huh?
71, 75, 81 and last matter.
Yourself, madam.
81 and?
Last matter, 84, my lord.
Ah.
These are in respect of Malcolm Cheru, my lord.
Unmute yourself. We are unable to hear you. At 2:30, that service
My
matter.
lord.
Madam, no an application. They must have been linked by some judicial order. The whole problem arises because you make oral mentions like this.
Court commissioner was appointed, my lord, in these matters.
81 and last matter.
It is directed to be listed. Nothing is being done, madam. It is listed before a bench in which Justice Shravan Kumar is not a member. Fine.
Obliged, my lord.
Application there be
Let's
Yes, Mr. We will take up his case and thereafter your. Yes, Mr. Ah, no, that's all. Yes.
28, my lords, were asking where is the inquiry report, my lord, page 28. Page 27 is the formal letter, my lord. Page 28 is the inquiry report.
No, we wanted to see what is regulation 24.
Regulation 24, my lord, employee conduct regulation, it starts at page 5 onwards.
Huh?
Page 5 onwards, employees conduct regulation. 24, your lordship will get it at page.
He has challenged it. What ground? You have to tell petitioner's case also.
Page
What ground he has challenged?
He has said these are all arbitrary at the end of the matter. Nothing, not a specific ground was raised. Page 11, your lordship would
Yes, arbitrary. What is regulation 24?
Page 11, your lordship would see regulation 24, acts of misconduct.
Page 11.
Yes. On the left side, your lordship would get it.
Acts of. All.
A breach of any of provisions of these regulations shall be deemed to constitute a misconduct punishable under the Andhra Bank Employees Discipline and Appeal Regulations. He
Yes.
said this is arbitrary. No grounds are given as to why this is arbitrary.
What else?
That's the end of the matter. Then throughout the grounds, Malad, that is arbitrary. This is arbitrary. Malad, when this inquiry report,
So everything is arbitrary, right?
when inquiry report was given, asked for his comments, he said, "I will not give the comments unless Delhi High Court."
Slip. Where is it? No, not. I want the flag. Every day, I mean, I have to ask, right? Why do you keep it that at a distance? It should be. So how many witnesses examined? 4 witnesses.
4 witnesses were examined.
And
of the management witnesses.
and
Then
he has examined himself.
He has examined himself.
All right.
Then he wanted another 4 to 5 witnesses, all the top officers to be summoned for him as his witnesses.
That you told us, Mr. We remember, right? We heard for 15 minutes that you are again telling that he made. We are asking how many. You are insisting he made an application.
That was rejected, matter.
Because he did not show how they are necessary for this thing and connected with this case.
And
we
as
know
far as
that.
judicial review minute, last 6 and 7, Union of India was Constable Sunil Kumar 2023 3 SCC, which starts at page 72 minute. They spoke, and the second judgment was also latest minute. IOC was a Rajendra Dharmitra on the scope of the judicial review. Inquiry charge sheet given.
Can safely presume that we know a bit about scope of judicial review.
My only request is, I have to present that's the end of the matter. Not that you will not, that's all. I once again apologize, my lord, for
No, nothing. No, why should you apologize? Yes. That's it. So what are the grounds on which you are challenging this order and regulation?
Yes,
please tell us.
Coming to the document of 23rd June 23.
So first tell your submissions, Mr. What grounds you have filed this writ petition?
Its complete
One
answer is
second.
there in this document, synopsis of that one.
Fine, all right. We have understood then. If you don't have to, since yesterday you are referring to synopsis, so we will go through it. Don't, that's why Legal Services Authority has engaged you to argue like this, right? No facts, everything is in synopsis. Sit down, we will go through it.
I'll be highlighting the points, Lord.
Nothing. It's too late now. Highlight it before Supreme Court now. Go. Yes. Please sit down. in this writ petition, comma, the petitioner has Hmm?
Regulation 6, my lord, at page 15, 1.5.
Regulation 6.
Page 15, 1.5.
Acha, no. 1 minute. The service conditions of the petitioner is governed by Andhra Pradesh, Andhra Bank. Delete.
Please. Sorry, not morning. I apologize for.
No, we had something to keep us busy since yesterday. So which case this was item 33? No, the other one. 45. Okay. So like IAs are disposed of, you should write, then again they will show it pending. Fixing an early date and all that. Yes.
Petitioner in the writ petition is the appellant in this appeal. The writ petition was dismissed at the admission stage. But the WP is filed questioning certain mutations carried out by the respondents.
Yes.
But the writ petition was filed challenging the mutation carried out by the official respondents pursuant to an order which according to us is non-existent. The case of respondent number 4 and 5 who are the unofficial response was that the mother of the petition had sold an extent of 6 acres 30 guntas under an unregistered sale deed in the year 1972. The date is missing. Under the Telangana Act of 1971, there is a provision wherein in respect of sale of agricultural lands by an unregistered document can be regularized on filing an application to the Tehsildar. There are rules prescribed wherein notice will have to be issued to the vendor and then he will decide, and then upon payment of stamp duty as was required under the document would be regularized. These are the rules which govern the. Such an application seems to have been filed by the respondent number 4 and 5, now 4 to 6, before the Tehsildar. And according to them, he passed an order which is at page 18 of the material papers. The writ appeal. Page 19 is the pro forma application. Then the translation at page 20. This is a pro forma order. In fact, there has to be some reasoned order. Now, when we made an application for furnishing the copies of
page 20 is the order.
Is the translation. It is in Telugu. It is in 19. 13 being pro forma. According to them, there is also confusion in respect of file. File number is ROR 428 of 96, and in some places it figures as 423 of 1996. But anyway, now both files are not available with the respondents. When we made an application, because if this is an order passed under the Act, there is a provision for appeal. The aggrieved party can file an appeal under section 5B of the ROR Act. So when we came to know, we filed an application to furnish a copy of this. The reply is that there is no such proceedings available in their records. Then we were constrained to file a writ petition before this court, challenging this proceeding, saying that since these are non-existing orders, let there be no mutation. The learned judge dismissed the writ petition on the ground that since there are no orders and no mutation is being carried out, as of now you have no grievance. As and when any grievance is there, you can always approach the court. Then being agreed by that, we find a writ appeal before this court. When this writ appeal came up for consideration, the orders dated 10/12/2007 came to be passed. The Rosham may kindly have a look at the orders dated 10/12/2007. That will clear the issue. In WA 1721 of 2005. May I read now? 10/12/2007. This is a docket order was passed. 10/12/2007 in WA. This very writ appeal. There is a docket order. In fact, this order was also drafted.
Yeah, what is the order if you can tell?
The order is they admitted that that orders are non-existent and they will conduct an inquiry. Your Lordship, may I read the order, my lord? That will make it.
10, 12. Ah, yes. Grievance.
The grievance of the writ petitioner appellant was that mutation of land was made on the basis of non-existent order. The learned single judge recorded submissions of respondent that no mutation has taken place. But later on it appeared that respondents agreed that the mutation had taken place. According to them, no order has been passed, and particular passbooks were also issued on the basis of mutation.
This will lead into an adjournment. He will seek adjournment. No idea.
That is what I am told. It would require.
We have searched, no records are available. Neither the inquiry was concluded, my lord. There is no inquiry file also.
In that event, they have to only reverse the entries.
Then?
That's all we are saying.
Lord, as per the new act, my lord, there is
So if a mutation was made on the basis of an order which does not exist even according to you,
yes,
then how do you justify the change? And entry in revenue record doesn't confer any title. If you have any title, go file a suit.
One submission. They have stated it that the files are not available, but they have not stated that it was not non-existing.
He is saying
Because today itself they have given the copy of that inquiry, and they have stated it. The register for the year 94 and 96 are reported to be unavailable in the record room. They have not stated it is not non-existing order. And one more submission is kindly have a look at the impugned order under challenge, page 18. Just my learned friend, I invited your lordship attention. In that one, the subject matter of the extent is 1 acre 30 guntas. Now they are seeking relief for 6 acre 30 guntas.
Let it be confined to 1 acre 30 guntas. That's sufficient.
And one more thing is, as on the date of filing for seeking for mutation of that one, this respondent number 7 has purchased this land in the year 99 from respondent.
1 acre and 30 gunta.
30 guntas. That is the subject matter of the orders.
Of survey number
479 of Oreda village.
479. Fine.
And
we'll confine it to that.
Just I will leave it to your lordship, but I would like to make one submission.
Yes.
And this respondent has purchased from unofficial respondents here in 5 and 6 in the year 99. Thereafter, the subject land is already converted from agriculture to non-agriculture by obtaining layout permission from the Board. Now, as on the date of after the 10 years, they have sought for the proceedings in the year 96 and they are seeking the orders in the year 2006 and they have obtained the said information under RTI. Whether the said information is genuine or not, basing on that information only, this writ petition has been filed. So let them decide because the third party is in question, this respondent number 5, 6, 7 are not in question and the individual plot owners from third parties are in question. Because I am not claiming any position and title as on today, how can I file a suit for declaration and other things? Because I have told you.
You are not the owner.
As on today, I am not the owner because I have alienated 20 years back.
So how are you concerned? I mean, those who are, what is the scope of the petition, Mr.?
That is the.
You are you want us to record a finding on your submission that you don't have a title, right?
No, I am not saying as on today, I am not
so
the owner.
putting all purchasers in jeopardy.
My respectful submission, because in the year 99, I have purchased and after that I have converted into layout.
See, Mr. The scope of inquiry, see, Mr. It's very limited. Please understand that if there is an order, then pursuant to which an mutation has been made, it's fine. If it's not there, they are saying records are not available. How do we presume that the order exists? And in any case, order of mutation, does not confer any title or anybody.
Yes.
In fact, in this case, the issue is, but I invite your lordship to section 5A of the Act of 1971.
Whatever.
That is regularization. That is what was affected according to them, based on which a mutation is carried out. Those orders are missing now.
As of
now, another requirement of them is that that time they must put me to notice.
Order of regularization dated?
That is what is at page 19.
1996.
16.8.
1996.
No, this is mutation, right?
Yes.
No, not mutation. No. That is the regularization.
Regularization.
After this, mutation was carried out based on this order.
Right.
There is no order to that effect, mutation order.
Oh.
But may make
and then another aspect.
And this thing is their stand is that 16.896 order does not exist.
Another thing is there are two challans referred to in that order. It has been filed that those two chalans are also non-existent, they are fabricated.
All right.
There is a report by the concerned treasury office. That also we have filed before the court.
Yes, write down, but this intra-court appeal.
I make a submission before on this. As on today, my lord, the revenue authorities do not have any power seeking mutation or reversing, my lord.
Now,
my lord, under the 2020 Act as of now, my lord, because 71 Act has been repealed, but the 2020 Act, also, my lord, the land has already been converted to non-agricultural land.
No, in fact, today's position is this land is acquired for ORR and the amount is now kept with the land acquisition officer. Both of us will have to now make a claim before the LAO. So that's a separate issue. This will clinch that issue.
No, but what about this? Are they in a position to this thing mutate your name?
No, I don't want mutate. I want their names to be removed. So my name will automatically go back. Whatever it is, these orders are non-existent. The order has to be, that order of regularization will have to be set aside and the consequential mutation has to be set aside. The lordships are not directing any names to be incorporated today. Those names which have been fabricated, the proceedings will have to be set aside. That is enough for us. I am not saying mutate my
Collector may be directed, my lord, to inquire. Second respondent, district collector may be directed to inquire afresh, my lord. And
What inquire and give to another round of litigation, right? He will be standing in the queue after a.
In any event, today may not the land is acquired. Neither of us have possession.
any other effect?
That my friend may not be aware. It is acquired under outer ring road. I have a copy of the LAO proceedings. The amounts are kept in deposit because there is a title dispute.
So the prayer is only to reverse the entries made in the record.
That's all. To restore what was there earlier, that's all.
This intra-court appeal emanates from an order dated. This intra-court appeal emanates from an order dated. Over. Oh. Achha, we couldn't get more cases due to digitization, right? Hmm?
They'll need this collector, they get it.